And Judge, approaching is Ms. Brenda Maxwell in case number 23-930 CFMA. Judge, as you may recall, Ms. Maxwell was previously evaluated for competency and was in fact found competent to proceed. Mr. Sullivan has extended a plea offer of possession of methamphetamine, a withhold of adjudication, and only 18 months of probation. The issue I'm having with Ms. Maxwell is that she wishes to be charged with a firearm. She's worried about her co-defendant being charged for it. I've tried to explain to her my job as a defense attorney is not to make things worse for her, to get her out of this as easy as possible. But Ms. Maxwell is wishing to not, if I understand correctly, to not accept this plea offer because she wishes to be charged with an additional crime.
That's not your decision to make.
My fingerprints are on those guns.
Don't care.
Okay.
Listen to me. Just because you want to be charged with something doesn't mean that the state has the obligation to charge you with anything. So if that's what's holding you up, you're messing yourself up.
Well, I'll just do what's right then, because I was just trying to do what's right.
Well,
because I took them in that car and my fingerprints are all over them, both of them.
Well, I've explained to Ms. Maxwell she could certainly testify in that trial if the state or the defense wished to use Ms. Maxwell as a witness in Mr. Albritton's case. Mr. Albritton is the name of the co-defendant. I believe his first name is Grover. Matt Grover.
What in the world would you want to be charged with?
Well, and Your Honor, not to go too far down the rabbit hole here, but before Ms. Maxwell is put under oath at all, either for the colloquy or if she decides to testify, I would point out that there's the in-car camera that captures Mr. Albritton trying to convince Miss Maxwell to take possession of the firearm in the car so that he doesn't get charged with felon in possession of a firearm. So just so she's aware of what perjury is and that I have the evidence of Mr. Albritton trying to convince her to take the blame for his actions. I just want to point that out there.
Can I say something?
No, ma'am.
Anything?
What does it matter? Good gracious, you've been charged with a felony. And you've got a plea offer, I guess, that you would take, and you're...
All right, buckle up. This courtroom isn't your typical legal drama. It's chaos in a robe. Brenda Maxwell is back, and the tension's already boiling. The judge reminds everyone she's been ruled competent. A plea deal's on the table. 18 months probation, no conviction. Sounds like a gift, right? But Maxwell, she wants to be charged for a gun that isn't even hers. Yeah. You heard that right. She's asking for a felony.
Can I say something? When I got in the back of that car, I said, "How am I?"
I don't care.
I didn't know how I was going to explain him the two guns. One I malfunctioned, and that's the reason I had two. And I asked him.
Listen to me.
You're going to yourself.
Absolutely could not care less. Either you want to take the plea or you're not, but you cannot direct the state what to charge you with.
Can I testify if I get with you and explain what happened?
I can't prevent you to testify from anything, but
testify. Can I be a witness for him?
That's up to his lawyer.
That's up to the defense attorney that represents Mr. Albert.
Look, I've heard all this.
We can pass it if you'd like to.
Hold on. Let me see. I've got an affidavit for violation of her release.
Yes, Your Honor. There was one. I believe you had ordered her to be present back in September.
Maybe I have another one.
I'm not
seeing one. All right, well she's taking care of that. All right, what are we going to do? We're going to set it for a trial or on the possession of methamphetamine?
Or do you want to resolve it today with the withhold?
I guess I have to resolve. If I can be a witness, I'll resolve it.
Ma'am, I can't tell you you're going to be a witness or not going to be a witness. I've got nothing to do with that.
And Your Honor, just for the record, my advice is to accept the plea. She has an opportunity to walk out of this courtroom without even being a convicted felon or a convicted criminal. With only 18 months of probation, any effort to make things worse has not been my legal advice. This is partly what led to the evaluation for competency in the beginning. Would you like to resolve it today?
Yes.
Okay. There you go.
I really found the stuff, so I'm really not even guilty of this.
All right, forget it. I'm not taking the plea.
Okay.
I'm not going to take it. We'll set it for trial. We'll set it for trial.
It's okay.
No, ma'am. No, ma'am. I'm not taking it. No, ma'am. No, ma'am. I've heard enough.
Sir?
No, ma'am.
I need to get
No. I'm not taking it right now. You can talk to Mr. Saline. I'm going to set it for December 12th. We'll set it for 10:30. You can talk to Mr. Saline and I may take it then, but I'm not taking it today when you're saying I'm not guilty and I'm not.
No, I'm talking about the drugs I found.
That's what you're pleading to. You need to talk to Mr. Saline before you come back up here.
Your Honor, that's 10:30 on December the 12th?
12th at 10:30.
Yes, sir.
All right, may I step over and sign a notice? We'll see.
Now it gets even wilder. Maxwell claims her fingerprints are all over the weapon, and she's determined to protect her co-defendant. The judge, sharp and steady, cuts through the drama. You don't get to choose what you're charged with. And just like that, the courtroom tightens. Body cam footage reveals her co-defendant may have pressured her into taking the fall. It's not loyalty, it's legal self-destruction. And the judge sees right through.
She just kept encouraging me to get a court-appointed attorney, and I simply said I don't want to, and she's very frustrated over that.
Your Honor, Maria Pinchenko for the record. I tried to resolve the motion with Mr. Hill. I explained to him my position that there is no legal basis that has been written into the motion, that I believe the motion should be dismissed, that it is simply a statement of facts of his opinion of what transpired in the case. I am uncomfortable dismissing the case or stipulating to the motion because I do not believe there's a legal factual basis. I explained to him that that is what I would have told his attorney if he had one. He has indicated that he would like to set this matter for a jury trial. I also indicated to him that he should, and I encouraged him to get a court-appointed counsel. I am not frustrated with his not getting court-appointed counsel, Your Honor. It's very difficult to speak with Mr. McCart. He keeps interrupting me. So I do want that on the record that I did attempt to try to resolve the matter. It appears that we'll be setting it for a jury trial after your ruling, depending upon what your ruling is on Mr. McCart's motion.
All right. Mr. McCart, would you like to place your motion on the record? You have to be brief. This is not a trial.
Yes. I filed this motion because of what he said, and I know what happened. I was there that day. My uncle tripped out the door, and my uncle went to the arraignment in Judge Toko's courtroom and said I did not assault him. He came to court and admitted this. And, I was not interrupting her. She would not give me a chance to speak. She just kept telling me what she wanted me to do, and that's not how it works. Now, me as my own attorney, I can go to the courthouse and get these transcripts from Judge Toko's photographer, file this motion as my own attorney at a trial. That's simple as that. That's all I want to do.
Mr. McCart. What are you in on? Because you're not in on this.
No, I have a drinking problem. I got in some trouble in Warren.
How long are you in for?
I've been in for 33 days. I'll be out next week.
Then the spiral begins. Maxwell starts pulling back from the plea, saying, I'm not even guilty of the drug charge. But this isn't the place for second thoughts. The state's offering a clean slate. No prison, no felony. Still, she's unraveling. The judge moves on, calling the next case. Enter Mr. Mart, representing himself. And just like that, we're headed into round 2 of courtroom chaos.
Yeah, I'll be out next week. And then I will go file to get the transcripts.
Here's what I'm going to do. I have reviewed your motion, and I can only grant things that are legally able to be granted. This motion to dismiss is only a statement of fact. Statements of fact need to be taken to a trier of fact, and that's a trial before a judge or a jury. There's no legal basis for a dismissal at this time based on this motion. So I am denying your motion to dismiss. We're going to set it for a jury trial. I'm going to set it for December 8th, 2023 at 8:30 a.m. in person in my building. Your bond is continued, so you are not held on my case. You're going to be in my building December 8th, 2023 for your jury trial. I am going to appoint what I'm going to call standby counsel. I'm going to allow you to represent yourself, but I am going to appoint an attorney to sit with you while you represent yourself, so that if you have questions on the legal aspect of how a trial is conducted or what to do, you have someone. It's kind of like a phone a friend. You'll have someone there. I'll allow you to represent yourself. I'll respect your wishes. But a jury trial can be a lot to handle when you've never done one before and you're not trained on how to conduct them. So I would like an attorney there for that process. Okay?
Okay, thank you. I can respect that, Your Honor. I'm only wanting to represent myself because I can't afford all these attorney fines. Every adjournment, I get recharged. I know this.
Actually, I waive all court-appointed attorney fees, so you're not charged in my court.
Now here's the curveball nobody saw coming. Mark claims he was falsely accused and says his uncle already confessed. But the judge stays cool. That's for trial, not this motion. Boom, motion dismissed. A jury trial is set. And Mark, no lawyer, just rage and confusion. But the judge gives him a chance. Standby counsel, a legal lifeline in the storm.
So would you like an attorney just to have one? You won't pay for it.
Yes.
I will waive them under the indigency rules.
I really never asked for a jury trial.
I don't want you to have that concern. All right. So do you want me to just appoint an attorney then, now that it's not a cost issue?
Yeah, sure. I have 2 daughters I'm supporting. I appreciate that. Thank you.
It's a non-cost issue. So here's what we're going to do then. I'm going to deny your motion to dismiss, but since we're asking now, we're going to officially appoint an attorney. I'm going to appoint an attorney, but we're actually going to set you for a pretrial before that jury trial date so that you can get to know your attorney and talk to them and not just come in on a trial date. Okay, so you can have some time to go over stuff with them. So we're going to set a pretrial up for December 6th, 2023 at 8:30 a.m. We'll set that up we'll set it up in person. That way you can talk to someone in person. I think you might be more comfortable with that. And then after that, if you still want a jury trial date, you can set it up with that lawyer, okay?
Can I ask you one question, Your Honor?
Yeah?
Is that okay?
Go ahead.
On my arraignment, when we sat in front of Judge Toko, my uncle actually came in. Does it mean nothing that he told her I did not assault him? It was a misunderstanding.
You know what, sir? The thing is, as judges, we can't dismiss cases without a trial or without a legal basis. So that's between them and what happens at the trial. You should talk to your attorney about that. I don't know what he said. I was not at your arraignment. But once the police are called and someone asks them to come out, it's not their choice whether charges get filed anymore. Then it's between the police and the prosecutor. And whether they want to go forward, that is a question for whether or not they talk to the prosecution about that. That's not something that they can come in and just tell me or Judge Toko, because we're not involved in that portion. We're here to have court available for hearings, and that would be things like pre-trials and trials. We're not here to just choose to dismiss cases.
All right, thank you, Your Honor.
You're welcome. We'll see you back on December 6th for a pre-trial. Have a good.
And finally, the fire dims. The judge offers Mark free legal help, and this time, he takes it. Turns out, he's just a dad trying to stay afloat in a system that drowns people in legal fees. You won't be charged for a public defender, she says. Pre-trial is set. Jury trial locked in. No dramatic gavel slam. Just a quiet echo of justice. Unfinished but moving forward.